Assalamualaikum and greetings to our respected lecturer, Dr. Akbar. We are from Group 4 and today we'll be presenting question 6 and this is our group members.
Next, I'm going to read the question, which the question involved Tamay Lan and Roy, which they were married in 2000, according to Chinese custom. Both of them underwent a tea ceremony to celebrate their marriage. Their marriage was then later registered under the Law Reform Marriage and Divorce Act 1976, and they have 2 children, Anne, 12 years old, and James, 3 years old. In 2018, Tamay Lan petitioned for a divorce on the ground that the marriage had irretrievably broken down and was granted a decree. Pending the decree being made obsolete and before the hearing of the ancillary application, the husband converted to Islam. He also converted the 2 children to Islam without Tan Mei Lan's consent. Tan Mei Lan comes to you and seeks your advice on her rights to maintenance and custody of her 2 children. Advise her.
The issue is whether the wife, Tan Mei Lan, has the rights to maintenance and custody of her 2 children under the Law Reform Act 1976 and Married Women and Children Act 1950.
Firstly, I will start explaining the law for maintenance. Firstly, I will start with definition. Maintenance in family law refers to a monetary payment made by one spouse for the benefit of the other spouse and the children following a separation or dissolution of marriage. A maintenance order is usually issued by the court requiring one spouse to provide financial support for the needs of the other spouse and any children of the marriage. Under Section 51, Subsection 2 under LRA Act 1976, upon granting a decree of dissolution of marriage, the court has the power to make provision for either the wife or the husband as well as for the support, care and custody of any children of the marriage. In exercising this power, the court may impose such condition on the decree of dissolution as it considers appropriate to ensure that the welfare and interests of the parties and the children are adequately protected. This can be seen in the case of Sumoy and Tu Myo Kim, which in this case, the husband and wife were married under the Chinese customary law and later separated. The wife filed for a divorce and applied for maintenance and division of matrimonial asset. Before the court determined this matter, the husband converted to Islam and argued that the High Court no longer has jurisdiction over him. However, the wife remained a non-Muslim and was unable to bring her claim before the Sharia court. So, in this case, the court held that the High Court retained jurisdiction to hear and determine the ancillary matters, including maintenance and division of asset. The court explained that under Section 51, Subsection 2 of the LRA, was intended to protect the right of the non-Muslim and the children when one party convert to Islam. The court further stated that legal obligation arising from the non-Muslim marriage cannot be avoided merely just because by converting to Islam, as doing so would cause injustice to the non-Muslim spouse and children who have made to remedy in the Sharia court. Moreover, under Section 3, Subsection 1, Married Women Act and Children Maintenance Act 1950, this section clearly imposes a duty on the husband to maintain his wife and on a father to maintain his legitimate child. Since marriage created a social and legal relationship between the parties, it becomes the responsibility of the husband to provide maintenance for his family. Moreover, under Section 92 of Law Reform Act, this law expressly provided that it is the duty of the parent to maintain or contribute to the maintenance of his or her children. This provision states that, unless otherwise provided by an agreement or court order, a parent must maintain or contribute to the maintenance of his or her children whether they are in his or her custody or in the custody of another person. So, such maintenance includes providing reasonable accommodation, clothing, foods, education according to the parent's means and station in life, or paying the cost and thereof. This provision imposes a general duty on both parents to maintain their children. However, under Section 93, Subsection 1, Para A to D, provides circumstances which empowers the court to order a father to pay maintenance for the benefit of his children. Firstly is where he refused or neglected to provide reasonable maintenance for the child. B, when he deserted his wife and the child remained in her care. C, during the pendency or matrimonial proceeding. Or D, when making or subsequent to making an order placing the child in the custody of another person. Accordingly, the law will places primary responsibility on the father to provide maintenance for his children. Last but not least for the law for maintenance, and is the case of Saraswati and Palakrishnan, which the court held that there was no requirement for a divorce petition to be filed under Section 93 of the LRA 1976 before a maintenance order could be made in favour of the children. Moreover, in the case of Siva Jyoti, anak perempuan K. Supiah, and Kunatasan, anak lelaki Celia, which the court explained that maintenance refer to any form of material provision that enables an adult to live a normal life and child to be properly brought up. Maintenance does not merely mean subsistence such as food, but also including clothing, housing, and other reasonable expenses necessary for daily living, all of which depend on the means of the person providing maintenance. Furthermore, it is well established that a father has a duty to maintain the standard of living that the children enjoy during the subsistence of the marriage. Next, for the law of custody, child custody is governed by Part 8 of the Law Reform Act 1976. Custody refers to the right and responsibility to care for, raise and provide for a child. The court may award custody to a parent, relative or any suitable person. In Section 88, Subsection 2, LRA 1976 provide that the welfare of the child is the court paramount consideration. The court focus on the child well-being, safety and best interest. Custody is decision aimed to minimize disruption to the child life. Next, Section 88, Subsection 3, Law Reform Act 1976 create a rebuttable presumption that children below 7 years should be placed in the mother custody. The presumption may be rebutted if the mother is proven unfit. Based in the case of CCKY and CCT, child was only 1 year old. Father failed to prove the mother was unfit. Hence, the custody was granted to the mother. Next, in the case of Wang Kim Fong and Tiao Ah Kau, Chong Kwong Fat custody awarded to the mother. Court considered her greater love, care, affection and dedication towards the children, which this demonstrate that the child welfare remains the primary concern. Next, welfare includes protecting the child from harm and ensuring security. Custody should be awarded to party best able to safeguard the child. In the case of Hu Tat Fong and Lim Chun Eng, court transferred custody from the mother's family members. The decision was made in the children's best interest. In the section of 89 of LRA 1976, it contains factors that may be considered by the court when determining custody, such as child residence, education, religion, case provided by others, the right, interest and welfare of the child, ability of parents to maintain and continue the relationship with the child, and the general prohibition against removing the child from Malaysia without proper authorization. This consideration gives rise to two broad implied factors. The first is the overall well-being of the child, which encompasses matters relating to residence, education, and religion. The second is the preservation of relationship among the child, parent, and other relevant persons, which include maintaining continuous contact and ensuring the child's emotional and social development. In the case of Tavamani and Sugumaran, custody of a 2-year-old child granted to the mother. Child has spent more time living with the mother, and the court considered that the mother could provide better care for the son. In the case of Gan Kukia and Gan Shiole, the custody awarded to the mother. Factor considered by the court is because children had lived longer with the mother, children were of tender age, and there are evidence of abuse by the father. The father also helped the fellow to maintain regular contact. Next, in the case of Tan Siu Yok and Ng Keng Huat, the court considered the parties' financial capabilities. Because a stable income help provide proper care and support, education needs, stable living environment. Financial stability is an important factor in custody decision.
For the application, Tan Malan petitioned for divorce in 2018 on the ground of irretrievable breakdown and was granted a decree. Thus, the Civil High Court possesses explicit statutory power under Section 51, Subsection 2 of the Law Reform Act 1976 to make provisions for her financial support as well as for the care, custody and maintenance of their 2 minor children, Anne and James. Even though Roy converted to Islam while the decree was pending being made absolute, his change of status cannot strip the civil court of its power, nor can it absolve him of his matrimonial obligation. Moreover, by applying the principle established by the Supreme Court in Tan Soo Moy and Tu Mu Kim, Roy's conversion to Islam does not divest the Civil High Court of its jurisdiction to determine these ancillary matters. Just like the husband in Tan Soo Moy, Roy cannot use his conversion to evade the legal liabilities and financial responsibilities that arose out of valid civil marriage. To hold otherwise would leave Mela entirely without remedy. As a non-Muslim, she has no standing or local standi to bring a matrimonial claim or seek financial relief before the Sharia court. Because Section 51, Subsection 2 of the Law Reform Act was specifically designed to prevent this type of injustice and to protect non-converting spouses and children, the Civil High Court retains exclusive jurisdiction to hear and grant Mela's application for personal maintenance and child custody. Furthermore, the legal relationship created by the parties' civil marriage in 2000 established Roy's responsibility to provide financial support for his family under Section 3, Subsection 1 of the Married Women Act. This provision imposed a strict dual duty on Roy. First, as a husband to maintain his wife, Melan, and second, as a father to maintain his legitimate children. Roy's subsequent conversion to Islam does not alter the fact that this obligation were legally born out of their civil union. Consequently, Melan can rely on Section 3, Subsection 1 of the Married Women Act to enforce her right to personal maintenance, ensuring that Roy continues to satisfy his financial obligation toward the daily necessities of his family. Turning to the children, pursuant to the case of Saraswati and Pala H9 and codified under Section 92 of the Law Reform Act, parents bear a continuous, independent statutory duty to maintain their children regardless of who has physical custody. Because the law places the primary financial responsibility on the father, Roy is legally obligated to provide for their reasonable accommodation, food and education according to his financial means. Thus, Madeline can successfully secure a child maintenance order against him under Section 93, Subsection 1 of the Law Reform Act, as her situation satisfies multiple statutory triggers. The application are made during the pendency of matrimonial proceeding under Section 93, Subsection 1, Paragraph C, and the order will be finalized concurrent with or subsequent to the court placing the minor children under her care, as provided under Section 93, Subsection 1, Paragraph D. The scope of this maintenance will be assessed truly. According to the standard in Civil Cuti Anak Perempuan Supiah and Kunatasan Anak Lelaki Celia, maintenance refers to any form of material provision that enable an adult to live a normal life and a child to properly brought up. It goes beyond bare physical subsistence of food and strictly includes housing, medical expenses and educational costs necessary for daily living. Crucially, Roy is under a legal duty to maintain the specific standard of living that the children enjoyed while the family was intact during the subsistence of the marriage since 2000. The Civil High Court will assess Roy's financial means, ensuring that his conversion to Islam does not allow him to downgrade or escape his responsibility to maintain his family's established lifestyle.
Moving on to the application for child custody. So, according to Section 88, Subsection 2 of the Act, stated the overall well-being and the welfare of the children is paramount consideration. So in this instance, Section 88, Subsection 3 of the Act indicates that 3-year-old James should be placed in the custody of Tan Mei Lan unless proven unfit. So Roy in this case has produced no evidence to rebut this. So the presumption stand consistent with the CCY case. So Tan Mei Lan claim is further supported by the proven maternal care and dedication toward her both children, as recognized in the Wong Kim Fong case, where the court emphasized the importance of a mother's affection and stability in a custody decision. Based on Section 89 of the Act, stated the two factors which are overall well-being and preservation of relationship. So based on this case, for the overall well-being, Roy unilateral conversion of Anne and James disrupt their established religious identity, schooling and stable living arrangement. Tan Mei Lan is the appropriate custodian to maintain continuity of care. For the second factor, which is the preservation of relationship, based on this case, Roy's secretive conduct undermines the cooperative parenting, risking harm to the children's emotional and social development. So based on the case of Tarvamani case and Ganko Kia case, the court emphasized continuity of residence and maternal care for young children. So since Anne and James have lived with Tan Mei Lan since 2018 and James' tender age necessitated maternal custody, this precedent support awarding custody to Tan Mei Lan. In this case, Roy unilateral conversion of Anne and James without Tan Mei Lan consent destabilized their religious identity, schooling and living arrangement, directly threatening their emotional stability and security. As a staple parental figure, Tan Mei Lan is the best place to safeguard continuity of care. So this aligns with the Hu Tat Fong case, where the court emphasized that sudden disruption to a child established environment undermine the welfare. So thus custody should rest with Tan Mei Lan to preserve the children's well-being and familial identity. The court will evaluate which party can better offer a secure and stable living environment. So any disparity in their incomes is resolved by the court's power under the LRA 1976 to order Roy to pay full maintenance to Tan Mei Lan. So this ensures household is financially secure and able to provide proper care, making custody with Tan Mei Lan the best guarantee of a stable upbringing for Anne and James. So this principle can be seen in Tan Seo Yok case. In conclusion, Tan Mei Lan has a clear right to maintenance and custody under the LRA 1976 and MWA 1950. Roy conversion to Islam does not absolve him of his financial duties as a husband and father. He remains responsible for housing, education and daily expenses to preserve the family's standard of living. Custody will strongly favor Tan Mei Lan, which since James' tender age requires maternal care and Roy's secretive, non-consensual conversion undermines family stability and threatens the children's welfare. So the children's best interests are therefore best protected by placing them permanently in Tan Mei Lan's sole care.